Welcome back to another J. Harris Academy of Police Training Roll Call. I'm Lieutenant Joey Sperlazza, instructor. Today we're going to be discussing an appellate decision, published opinion, that was just decided on June 12th, 2024. This is the State of New Jersey versus Taviaus Wilson, James Hooks, and Sidel Lotman. Here, the appellate division is telling us, can we, when we are searching a vehicle with probable cause, can we open up a locked glove box or locked container found within the passenger compartment of the vehicle? And here, the answer is yes, we can. It's important to understand, this case the probable cause was based on the smell of marijuana, and though we now have marijuana legal here in the state of New Jersey, we don't need to focus on the marijuana. It's just a probable cause search of the interior of the motor vehicle without a warrant. We can open up locked or sealed containers. Here are the details of the case. November 4th, 2018, Detective Christopher Zanni of the Bridgeton City Police Department was on patrol in a marked patrol vehicle when a white SUV pulled out in front of him. He observed that the SUV had illegally tinted windows. He activated his emergency lights and initiated a motor vehicle stop. He then smelt marijuana, establishing his probable cause to search the interior of the vehicle. He searched the occupants of the vehicle, found no contraband. When he was searching the interior of the vehicle, he used the key that was used to operate the vehicle to unlock the glove box. Once he opened up the glove box, he found handguns inside, placed the defendants under arrest. Once they were under arrest, they continued their search. They found marijuana, scale, and additional paraphernalia related to the distribution of marijuana. So the defendant appealed, essentially saying, we can't open up that locked glove box due to the increased expectation of privacy. Here in New Jersey, we follow the decision that was made in 1982 in U.S. versus Ross. If officers have probable cause to search a vehicle, they could search all of the containers found therein. They could search purses, they could search backpacks, and obviously the glove box within the interior of the vehicle. If that is locked, that's what we're being challenged here. If the probable cause justifies the search of a lawfully stopped vehicle, it justifies the search of every part of the vehicle and its contents that may conceal the object of search. New Jersey courts have consistently followed the rule announced in Ross that the scope of an automobile exception is limited to, but also includes, places or containers that could be holding the object of the probable cause search. The facts constituting probable cause are critical, not only in determining whether an automobile exception search may be initiated, but also in determining the spatial boundaries of the search. The New Jersey Supreme Court in the State versus Cohen, decided in 2023, reiterated, a search which is reasonable at its inception may still violate the Fourth Amendment by virtue of its intolerable intensity and scope. It is also well established under New Jersey search and seizure law that the scope of a warrantless search of an automobile is defined by the object of the search and the places where there is probable cause to believe that it may be found. State v. Estevez, 1983. What this means, if I'm searching for a handgun, I cannot look inside of a small satchel. If I'm looking for a handgun, I cannot look inside of an ashtray. If I'm looking for crack or any other small CDS, it would be reasonable to look inside that ashtray. So we have to understand what the object that we're looking for has to be found within a container size that is the container that we are now opening. For an automobile exception search to be lawful in its physical scope, the probable cause of search must be as to items or effects that, by their nature, could be concealed in the container that was opened. Cohen specifically addressed whether the odor of marijuana in a vehicle authorized a warrantless search of the engine compartment and trunk. The Cohen court did not break new ground, but rather reaffirmed well-established NJ precedent limiting the spatial scope of an automobile exception search. While the court in Cohen drew a line between places in and outside the vehicle's interior, it made no such demarcation between spaces and containers situated inside the passenger compartment. Indeed, the court made it clear that pursuant to the automobile exception, if an officer has probable cause to search the interior of the vehicle, that probable cause encompasses the entirety of the interior. The court also added, this holding Suppressing the weapons found in the engine compartment and trunk in no way suggests that areas within the interior of a car would require separate probable cause findings in order to conduct a warrantless search. We are not dividing up the interior of vehicles such that an officer would need to establish different or additional probable cause to search the front seat as opposed to the back seat, for example. When police have probable cause to search the passenger compartment, they also have probable cause to search a container located within the passenger compartment, including a glove box, so long as the container is capable of holding the object of search. Under Cohen's entirety of the interior ruling, a glove box clearly falls within the interior region of a vehicle. The glove box fell within the spatial boundaries of a lawful automobile exception search because there was probable cause to believe contraband would be found in the passenger compartment. The glove box was located within that compartment, and the glove box was a container that could hold the object of the search for which there was probable cause. State v. Wilson is a case of first impression in this state. They examined three closely related arguments. 1. Locking the glove box evinced greater expectation of privacy in its contents, invoking a higher standard of justification for searching it. 2. Locking the glove box rendered it inaccessible to the driver and passengers, and opening the locked container was a more intense form of physical intrusion than is allowed under the automobile exception. Taking the precaution of locking a built-in compartment or portable container exhibits a subjective intent to shield its contents from others, including law enforcement. The same could be said of other efforts undertaken to keep effects away from prying eyes or hands, including the installation of trapdoors, hidden compartments, etc. There is no constitutionally significant difference between consciously locking a glove box or article of luggage and consciously placing the object in a compartment knowing it locks automatically, such as a trunk in a traditional sedan. Nor is locking a container meaningfully different in terms of either subjective intent or constitutional effect from consciously hiding or camouflaging the object sought to be protected from discovery. All of these deliberate precautions are meant to prevent others from seeing, recognizing, or confiscating the concealed objects, and thus evidence a greater subjective expectation of privacy than if the person had simply strewn these objects inside the vehicle. The novel question is whether any such elevated subjective expectation of privacy categorically renders a locked compartment or container immune from the automobile exception search. Under the Fourth Amendment, no distinction is drawn between locked and unlocked compartments or containers for the purposes of the automobile exception. Whether locked or not, a glove box is just as readily mobile as the vehicle, and thus its contents are subject to the same inherent risks associated with mobility that gives rise to the automobile exception. Requiring a vehicle be impounded and searched pursuant to a warrant because the glove box is locked might unintentionally degenerate, not advance, motorist constitutional interests. An immediate search of a vehicle may represent a lesser intrusion than impounding the vehicle and detaining its occupants while the police secure a warrant. Though the glove box was accessible using the ignition key, and thus was not readily accessible when the vehicle was actually in motion, accessibility is not a required element of the automobile exception, and thus has no bearing on the lawfulness of the glove box search under that doctrine. Under New Jersey law, the permissible scope of an automobile exception search does not depend on whether compartments or containers within the vehicle are accessible to the suspects, either when those compartments or containers were loaded, during the operation of the vehicle, or at the time of the warrantless search. An otherwise lawful search does not become unreasonable when police either have to break into a separately secured container or have to use a key to open it. A search that is reasonable at its inception may become intolerable by virtue of the intolerable intensity and scope. This imposes limits not just on the boundaries of an automobile exception search, not only where within a vehicle the search may extend, but also on the techniques and tools police may employ to execute the search. That is, limits on the degree of mechanical force that may be used and the amount of damage to personal property. Using a key to open a lock does not interfere with the structural integrity of a vehicle, nor does it produce any damage, much less damage that is excessive or unnecessary. Unauthorized entry with its key is no different than any other method for gaining unauthorized access to a particular space or container in the vehicle. However, the use of a key to open a locked container or compartment is qualitatively different from using a pry bar or similar instrumentality or brute force to break open the container or compartment. Here, there was no insult to the structural integrity of the vehicle and no damage caused to the glove box. The manner in which the officers opened the glove box was eminently reasonable and thus lawful under the New Jersey Constitution. Police were authorized under the automobile exception to search the glove box for marijuana and executed that search in a reasonable manner. Accordingly, the handguns that came into plain view when the glove box was opened were lawfully seized and should not have been suppressed. This is a great case for us here in New Jersey, allowing us to unlock those sealed containers. I would still use caution if you had to use brute force or pry open any type of a compartment causing damage to a vehicle. As always, speak to your prosecutors. Call on scene if you have something that would be of that nature. The last thing that you want to have suppressed is that them saying that you exceeded the scope by breaking something open. However, if you do have a key for a briefcase, a lockbox, a glove compartment, and it's within that passenger compartment, you will be good to go. Until next time, again, I'm Lieutenant Joey Sperlazza, instructor with the J. Harris Academy of Police Training. Stay safe.